I know that perhaps some of the board members are familiar with me. I sent in a letter with several questions in August of last year, not fully happy with the answers that were provided to me, so I'll go ahead and ask some of those again. I do want to just briefly go over some of the information that I pulled out of the website, the DCA website, of the complaints for the fiscal year 2019-2020. The board received 10,868 complaints, and they closed 12,903 by the complaint unit. My first question is, can you please explain or give us an understanding of what the complaint unit does, the role, how do they make the determination of closing a complaint that was sent in? Because I know you said it was about 85% of that, that are closed during, within this unit. But I mean, are we talking about like frivolous claims then at this point? I mean, what goes into determining closing a case within the unit?
Thank you for your question. This is Jenna Jones again. So there are a number of factors that go into the initial review of a complaint or matter. When we talk about the 10,000 complaints that were received during the fiscal year 1920, there may be cases pending from the prior fiscal year. So that's where you're going to see the number increased to the 12,000 figure you presented, because we have cases that are still pending review and finalization or determination. So that's where the number can be increased. Now, the types of complaints that may be closed at the initial review may include cases that were, I'm using cases and complaints synonymously. I'm sorry if that causes any confusion, but a number of complaints we receive are out of our jurisdiction. They either need to go to the nursing board, the osteopathic board, or one of the other allied health boards. So we identify those as not being licensed with our agency or under our area, and we're going to refer those out. So last year, I believe that was, oh, that's a different graph, I'm sorry. There was approximately 1,300 complaints last year that were outside of our jurisdiction. I'm sorry, non-jurisdictional last year were 1,600 complaints, 1,694. It also, we may not have jurisdiction over it. It may be a billing issue. It may be something that doesn't fall under the unprofessional conduct. And then, so the initial review also includes, if we get an anonymous complaint, do we have any information? Do we have a patient name? Trying to identify somebody that we can go to or gather additional information. The anonymous complaints can be a huge amount of our incoming complaints, and therefore sometimes a number of those are closed. There's just a lot of factors involved. Sometimes we will send a request for a release of medical records, and we send a couple of requests, and we don't get a response.
But is there a process, and who reviews these complaints? I guess that's what what is the internal structure for determining where a case or a complaint should even be filed or moved towards, or is out of the jurisdiction?
Okay, so when the complaint first hits our office, it's going to go to our triage unit, which is called the Central Complaint Unit. That is their role, is to triage that complaint or amount of information, a TV report, news article, the malpractice report, an arrest report, whatever that may be, that is evaluated by the Central Complaint Unit and started on the process of moving towards the being sent for more investigation. But our initial steps are.
But the majority are in the Central Complaint Unit. The majority of the complaints are closed within this unit. So I'm trying to figure out who are the decision makers within this unit that make the decision to close a complaint.
The analysts, we have a staff of analysts and managers, and they are the ones that are reviewing the cases. We also send those cases before a medical consultant group, and they're helping us review the cases to determine if the cases appear to have a possible violation.
So my understanding is that a complaint doesn't go to a medical consultant unless it's considered now an investigation. Is that accurate?
That is not accurate. The cases that we receive the records on, that we're able to obtain records on, and we feel that there may be a possible violation, those all go to a medical consultant review. The medical consultant review is in accordance with one of the statutes 2220.08, where someone who has similar training and experience reviews the records, and determines if there's a possible violation in the matter. And that is, once we clear that hurdle, then the case goes out to HQIU or CIO for further investigation.
Okay, and I know you did mention at the beginning there that there's analysts and managers at triage within the complaint unit, right?
Yes, ma'am.
So do you believe that they have, or they're prepared to provide the proof or an understanding of the standard of care?
Mr. Hurtado, or Senator Rivera, they're not determining the standard of care. They're evaluating it to present it to the medical consultant, who is a licensed physician who will be determining if a standard of care was violated.
But some don't go to the medical consultant, right? I mean, they make the determination if it goes to the medical consultant next. Is that accurate?
Well, if it's a situation where office staff were rude to the allegation is that the staff from a clinic were rude or something, you're correct. That would not go to a medical consultant. And that is a case that we don't necessarily have jurisdiction on. If it's regarding a physician's care. So, yes, I'm not going to say every case goes to the medical consultant, but if it's involving patient care, yes, it is going to the medical
So what
consultant.
percentage would you say ends up going to the medical consultant of the cases that come in?
I would be happy to research that and get you a number. I'm sorry, I don't have that with today.
The other question I have regarding the central complaint unit and/or when a complaint goes to the medical consultant, is there any screening that is done through the National Practitioner Data Bank?
We receive complaints, or we receive reports on the National Practitioner Data Bank, and we initiate complaints from those. That's a little bit different process because it's
Can you
usually
explain that?
based on another out-of-state practice or out-of-state action.
Which one? Can you explain that to myself and others listening in?
Absolutely. So if we receive a report from the National Practitioner Data Bank, that could be action taken by a hospital. We're going to follow up and see if we already have an 805 report, which is a mandatory report on that. It may also be an out-of-state action taken against a physician, and that's going to be initiated and a complaint's going to be initiated, but it's going to be considered an out-of-state case, and that that's when we start getting the information from the other state, and we take a look at it that way. We don't have jurisdiction to obtain all of the records from the hospitals in those states, but we're obtaining the other state's action that they took against the licensee and moving forward with the complaint or case based on that matter.
But you have the ability to go into the database and look up a doctor that maybe there's a complaint about in front of you and get background information as to whether or not there's been disciplinary action in the past in some other state in regards to this doctor.
We're actually going to have that in our database.
So are you reviewing your database at the
Yes.
moment? And does that have information about disciplinary action in other states?
If it's been reported through the National Practitioner Data Bank, yes, it's going to be in our database.
So you take that into account in terms of, do you take that into account or the information when you're doing the triage?
We're going to look at the entire history, yes. It all depends on what the matter was. Is it current? Is it 10 years ago? So it's going to be evaluated, but it depends on the details involved.
Okay. And I know that there was mention of some sort of document that you received or notification if there's an individual that received disciplinary action in another state, or then you look into it and then I'm assuming you revoke the license at that point?
It would depend on the discipline taken in the other state. If they were given a public reprimand, we usually generally follow what the other state has done with our own action, but it would depend on the seriousness of the action taken in the other state.
Okay. Now I want to shift a little bit back to the medical consultants. My understanding is that in terms of the medical consultants, you have, they're permanent intermittents or they're part-time. Can you explain a little bit more about their actual role, if they're actually state employees, how often they come in? And I know there was mention that there's about 33 consultants that you have, medical consultants.
The medical consultants, for the most part, are independent contractors that we have there's more than 33. You may be speaking, we have a full panel of medical consultants. You may be focusing on the number that are involved with HQIU and serve them directly. We do have a chief medical consultant that is on staff, but the other medical consultants that we're referring these cases to are not full-time employees of the board. They're all contractors.
So they're contract employees, they're not state employees. Is that correct?
Yes, ma'am.
Okay, and I know there's also expert reviewers. Are those contract employees as well?
Yes, ma'am, they are.
Okay. And how many expert reviewers do you have?
I believe the last number in the pool was somewhere over 600.
Over 600?
Yes, ma'am.
Do you know how many do you have per specialty?
I could get that information for you. I do not have that at this moment.
Okay. I want to also just briefly mention that I represent the parts of Fresno, Tulare, Kings, and Kern counties. I did some more or additional research. I looked through the active licenses with disciplinary action. With no public document, there's about 248 active licenses with disciplinary action, and with a public document available, there's about 146. also wanted to mention that there were 140 licenses that were surrendered, but some after the fact. And I think that you touched on this just a little bit earlier, that when you get the notification, the national notification, then you take action. And it seems like that's the case. And so that's why I asked earlier if you looked into if you did kind of like in a preventive way, looked at the database to look at, or look up doctors that have complaints against them, because it just seems like a lot of it seems like there's not a lot of information that is being collected from there, or that we're informing ourselves from that national database. So I wanted just to point that out. It's just a statement.
Okay. I'm not, yeah, thank you.
Let me just. So I know that in my original question, or the letter that I sent last year, one of the first questions I asked was, can you please provide a review of why license revocation was originally considered as part of a disciplinary action but was not issued? Do you have any additional comments or a response to that?
If I can take that up, Senator, it's the form of pleading that is done as part of the legal process in the accusation stage is that we set out a whole range of what possible sanctions may be available. But it's only after the conclusion of the investigation that we have a better sense as to what is achievable. So it is routinely stated in accusations that one of the options is revocation. But that does not mean that that will ultimately be the appropriate sanction.
The other topic I wanted to kind of cover is probation monitoring. I know there's also, when a doctor has been disciplined and there's someone that actually monitors them locally, why are the names kept confidential? I mean, if I am I'm a consumer, right? I'm concerned about, I want to make sure that I go to the right doctor, but there's a doctor that's been disciplined in my region. I mean, if I have even a complaint about a doctor or have some concerns, how do I express those concerns if we have no knowledge of who that individual is?
You mean who the probation monitor is?
The one that works directly with the doctor, locally. Is that what they're called, probation monitors?
The board employee that would be monitoring the doctors on probation would be our probation monitors. I am not aware that she or that individual has not been, I understand that individual has had contact with the high-profile case that I believe you're referring to, but I was not aware that their identity was confidential.
So probation monitors information is not confidential, it's public, is what you're telling me. I can have access, or if I call in, I can get that information if I request it.
Gary.
I will double check on that.
Okay,
May I get back to you on that?
sure.
Thank you.
Do you have any guidelines set up? and it seems like you kind of just, it's a case-by-case basis, but do you have any sort of guidelines that you use to issue citations and/or probation?
Yes.
Can you explain that a little bit?
If an individual on probation is determined to not be complying with some of the, either a specific term of a probationary order, the first step is a citation process, depending on the extent of the violation. But a citation may be utilized to address noncompliance.
Okay. Now, does a consumer have the ability to file, I don't know, some sort of, if there's an outcome in a particular complaint and/or case, does a consumer have the ability to disagree with that outcome and just petition once again?
The individual complainant may certainly write us and let us know that they're unhappy or displeased with the final outcome. But as far as amending that outcome, I am not aware that that is an option because the matter has already become public and has been finalized.
I mean,
But we
is it
certainly take that into consideration.
after the fact? I mean, isn't this board about patient protection?
Yes, ma'am.
Okay. But there is a process for doctors to be able to do that kind of thing. If they disagree with the outcome, they can file some form of
Yeah, so,
counter complaint. Is that accurate?
Senator, if I could address that question. Yes, you have pointed out to what many people in other jurisdictions have thought is an anomaly in the act. Basically, the complainant is the medical board. The doctor is the respondent. If the doctor is not happy with the outcome, there is a right of appeal. There is no such right of appeal about the complainants. Now, in other jurisdictions, what they do is they have another board which has a right to appeal decisions on the basis of public protection, and particularly on the basis that the sanction is not sufficient to protect the public. For example, in the United Kingdom, there's a body called the Professional Standards Authority, a sort of a regulator of regulators, which has that role. That's not what we have in California. There's no right of the complainant, like, for example, the patient, to appeal.
Right. That's
correct.
Okay. My next question is, what proportion of cases investigated by the board are cases that involve patients using Medi-Cal versus commercial insurers?
I don't know that we have that information, Senator. We'd be happy to try to get it, but I'm not sure that's captured on our database anywhere.
Okay. Well, I could be here all day and ask additional questions, but I will leave it at the moment as is. Thank you for your answers.